So, one of the most common misconceptions that we have in criminal law is that Miranda rights are required in every single case, but that's just not true. It's only required in certain circumstances. If an officer is just investigating a crime, for example, they pull you over for speeding or for DUI investigation or drug investigations, it's not required. And that is the most common question we get when someone is arrested and calls our office. So, to start off, what are Miranda rights?
So, as many of you guys know, Miranda rights are the common rights that they read to you when they're investigating something. They are the right to remain silent, the right to have an attorney, the right to have an attorney appointed to you if you cannot afford one, and then also that anything you say can and will be used against you. Like Brandon said, they don't always have to be advised to you. For it to be required, there has to be two elements that are met. The first, that it is a custodial interrogation. So the first, that you're in custody, and secondly, that it is an interrogation. Brandon, do you want to go over what custody generally means?
Yeah, so like I said at the very beginning, an investigation of a crime is not where you are required to give Miranda rights. It's once you are actually in custody. But the question of whether you're in custody is not as simple as people think. Most people think that is akin to, hands behind your back, in handcuffs, in the back of a police car or at the police station. People think of a small room being interrogated and being questioned, right? And that is being in custody. But you can be in custody before you're even in handcuffs. And so what you look at, how is the conversation between you and the officer? What is their demeanor at the time? Look at, the totality of the circumstances to argue that for all intensive purposes, you may have been in custody. And if we have an argument that you were in custody, then at that point, you are potentially entitled to Miranda rights if you are also being interrogated while in custody. So what is required for you to be being interrogated?
Yeah, so for an interrogation, the officer has to be asking you questions that will likely elicit a incriminating response. So, for example, if they're investigating some sort of simple possession or drug offense, if they ask you, are these drugs yours? Whose drugs are these? Where are the drugs? Those are all incriminating because you can answer with anything that can incriminate you, whether you possess those drugs, whether you have knowledge of where those drugs are. Now, if the officer asks you, how's your day, or what color is the sky, those aren't incriminating because they're not investigating that investigation through those questions. So for Miranda to apply, they have to be asking that kind of question.
Right. And so I guess just as a very basic level, both of those are required, right? And so if the officer asks, are those drugs yours? It may or may not apply. Yes, it may be an interrogating question, but if you're not in custody, then your answer could potentially be used against you, right?
Right.
And so it's always important. That's all we talked about. Even if you're not in handcuffs, we as defense attorneys can potentially argue that you were in custody, but it depends on your freedom of movement.
Right,
factors,
exactly.
Right? So again, both of those are required, but the law does not mean that it automatically cannot be used against you, right? And so if you are in custody and being interrogated, but your attorney does not mention that to a prosecutor and then file a motion to bring it into court, it does not matter. And so the only way that it becomes effective in court is to file a motion to suppress any of those statements that you made. Most people think that the case should be dismissed if I am not read my Miranda rights. We actually went to a conference last year where we got to see a jury deliberating on a case, and all they wanted to talk about was Miranda rights. Almost every potential new client case we take, clients always want to talk about their Miranda rights. But it isn't an issue unless you file that motion saying that they're in custody and being interrogated. Without it being suppressed, statements can be used against you unless the judge finds that those two requirements were met and therefore should be suppressed. And so it's really important that every little detail is evaluated to see should Miranda rights have been read, and if they should have been read, the recourse is suppression of those statements so they can't be used against you. Unfortunately, it's not a dismissal as we wish and a lot of our clients wish, but there's definitely some leverage that we can get from suppressing those statements, which leads to, we talk about suppression, but we haven't talked about how can you invoke your right to remain silent or those Miranda rights. So do you want to talk about that?
Yeah, absolutely. So if the officers do read you those rights, you can waive those rights by continuing to speak with them. If you want to invoke those rights, you have to explicitly say so. you can say, I'm not talking to you until I have an attorney, or I want to invoke my rights. There's case law saying that if you say, oh, I think I want an attorney, or do I want an attorney? Should I have an attorney? That is not sufficient. You have to very explicitly say that that is what you want. Unless you say that, they can keep asking you questions. And while you think you may have invoked them, it's actually not sufficient. So if you're ever in a position where they read you those Miranda rights, be very clear that you want an attorney to make them stop asking you questions. If you are very clear and they continue asking questions, then we have a suppression issue there because they're violating your rights. Even if you do invoke that right very clearly, you can also reinitiate conversation later on, which we do not advise to do, but you have to keep in mind that if you're in transport with an officer for 30 minutes, at some point sitting in the back seat, you decide to start speaking, just because you invoked those rights earlier doesn't mean that that officer can't ask you questions because you're the individual reinitiating. Now, the officers can't reinitiate, but if you do, then they can use those statements against you.
Yeah, so we always advise clients, please invoke your Miranda rights. Anything you say can and will be used against you. There is almost nothing you can say that is going to benefit your case when you are already in custody, or for all intents and purposes. You're just giving more evidence to convict you of the crime. They don't even need witnesses that they may need otherwise once you admit to something. So in a case of a domestic assault, for example, right, it's he said, she said. So they need, if you're the male and you are alleged to have committed domestic assault, they need the victim to come to court and testify and meet all of the elements to establish a domestic assault. But if you admit to it and admit to whatever that assault is or whatever that crime is, they can use your admission against you. They don't even need that witness or victim anymore. So invoke your right to remain silent, make the state prove their case. Don't prove it for them.